Hi, I'm Judge Dulcich, a Kern County Superior Court judge assigned to hear family law cases. I'd like to talk to you a little bit about presenting your case in court. Typically, in family law cases, the family unit has broken down. Parties go their separate ways, but can't agree on such things as their children, custody and visitation, finances, and property. Very often the parties that come in here are unrepresented and don't have an attorney with them. Remember, it is your case, and half of the job is filing your paperwork correctly, and the rest of it is presenting your case in court in front of the judge. Emotions can run high in family law cases, and we are aware of that. You may be confused, scared, upset, and not know what to expect when you walk into court. Remember to always be respectful. Only one party should speak at a time. Say your piece, present your evidence, let the other party present their evidence, and listen to what the judge has to say. The video you're about to watch will give you an example of how a proceeding is done with respect to custody and visitation. Hopefully by watching the video, you'll feel a little more confident when you come to court about presenting your case to the judge.
Hi there. We work for the Family Law Access Project, a project designed to help individuals who have family law cases who do not have an attorney to help them with the paperwork and to represent themselves in court.
As Judge Dulcich said, this video is meant to help you better present your case in court. At the end of the video, we don't expect you to be a polished attorney. However, we think that you will better understand what actually happens at a hearing because we'll show you a hearing and explain things to you as they happen.
The following is a dramatization with volunteer actors. All characters and case information is fictitious. Any similarities to real-life individuals or real cases is unintentional and strictly coincidental. The video is for informational purposes only.
It says here Department 15. Let's see if you're on there. Yes.
How you doing? All parties for Gibla versus Filfo may enter. Make sure you have all your pagers, your cell phones, any electronic device turned off. Make sure you're not chewing any gum. When you're seated in the audience, make sure you're not talking. Other than that, we can enter.
Today we have Ms. Gibla, who is seeking to change the current court order regarding custody, visitation, and support. In order to get that change, she has the burden of proof or the responsibility to convince me that that change is necessary. Basically, she can win or lose her own case. To prove her case, she has to show, first of all, that there has been a change in the circumstances, and second, that it is necessary to the best interest of the child that this order be changed. Basically, she has the responsibility of showing this by what is called a preponderance of the evidence, which is to say, she has to show that 51% or a majority of the evidence supports the change that she seeks. Now, Mr. Filfo was also going to have an opportunity to present testimony to challenge the evidence that Ms. Gibla presents. Let's get started. Okay, we have Gibla, Abigail Gibla v. Walt Filfo, case number S-1501-FL-12345. And who do we have here?
Adam Lawless representing Mr. Filfo, who is present.
And who are you?
Abigail Gibla.
Would you please spell your name?
Abigail Gibla.
Okay. And Mr. Lawless, would you have your client state his name and spell it?
Walt Filfo, W-A-L-T-F-I-L-F-O.
And then Ms. Gibla, am I pronouncing it correctly?
Yes.
Okay. Very well. I'll have the judicial courtroom assistant place the parties under oath.
Please raise your right hand. Do you
swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I do.
You may be seated.
Ms. Gibla, do you have any witnesses?
Yes, Your Honor.
You may call your first witness.
Miss Elizabeth Friendly.
A witness is one way to get evidence before the court to support your case. Here we have Ms. Gibla calling Ms. Friendly, her friend and neighbor, as a witness. Anything that Ms. Friendly says under oath at this hearing is called testimony. Testimony is one form of evidence that the judge may consider.
Do you want her to stand by you, or do you want her to sit up here at the witness stand?
She'll be sitting in the witness stand, Your Honor.
All right. The judicial courtroom assistant will place her under oath.
Please raise your right hand. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, please be seated.
Notice that Ms. Gibla has a list of questions that she's going to ask her witness. You too should have a list of questions written down so that you don't forget anything. Your questions should be clear and direct. Before the hearing, you should have already talked to your witness and gone over what questions you're going to ask him or her. By the time of the hearing, you should trust your witness to tell the story in his or her own words. Nothing that witness says in court should be a surprise to you.
Miss Friendly, do you know me?
Yes, you've been my neighbor for about 8 years.
Do you know my ex-boyfriend, Mr. Filfo?
Yes,
How do you know him?
he used to live with you.
Do you know our son, Tommy?
Yes,
How do you know him?
I've babysat him for 4 years.
Note that Mr. Lawless, Mr. Filfo's attorney, is listening and taking notes. This is a good practice. If you're not asking or answering questions, you should be listening and taking notes as well. It will help you organize your thoughts if you want to ask questions later.
Where does Tommy live?
With you.
Do you still babysit Tommy?
Yes,
Where do you babysit him?
at your house.
How often do you babysit?
3 times a week and sometimes on weekends.
Ms. Gibla is asking questions of her witness or doing a direct examination of that witness. First, she starts by asking background questions like whether or not Ms. Friendly knows her, whether or not Ms. Friendly knows her ex-boyfriend, Mr. Filfo, and whether or not she knows their son, Tommy. This is important because you need to show that your witness has personal knowledge about what he or she is about to talk about. If you can show that your witness has personal knowledge, the judge will probably accept that witness's testimony.
Does Mr. Filfo still live with me and Tommy?
No.
When was the last time he lived with us?
I've seen him move his stuff out about a year ago, and I haven't seen him stay the night over since then.
Do you ever see him at my house?
Sometimes when he's picking up Tommy for his visits.
Have you ever seen him at any other times?
Well, I've noticed him twice hanging outside your house trying to look into your bedroom windows. And I've also seen him drive slowly by your house a lot of times.
Why do you think he's doing that?
I think he's doing that
Objection. Call
because
speculation.
Mr. Lawless, Mr. Filfo's attorney, has just made an objection. An objection is a way to keep evidence out of the courtroom so the court can't consider it. An objection is used to keep a witness from testifying about certain information, or it can be used to keep out other forms of evidence like a document or a photo, Whenever you make an objection, you must give a reason for the objection. Here the attorney said, objection, cause for speculation. Cause for speculation means that a witness is not going to be able to testify about something he or she does not have personal knowledge of. Let's see how the judge handles this.
Sustained. Ms. Gibla, your witness cannot testify about something which she has no personal knowledge of. She's not a mind reader. She cannot possibly guess why Mr. Filfo would do or would not do something. Ms. Friendly, you cannot answer that question. Ms. Gibla, next question.
When an objection is made, a judge must decide and rule on that objection. The judge may either sustain or overrule that objection. If the judge agrees with your objection, the judge will sustain. That means that the witness will not be allowed to answer the question, or that some kind of offered evidence will not be allowed in. One way to remember this is that the S in sustain means S for stop. So that means that the witness cannot answer the question and the evidence will not be allowed in. If the judge disagrees with your objection, he will overrule it. That means that the witness can answer the question, or if you're offering some kind of physical evidence, that evidence will be allowed in and will be considered. One way to remember this is the O in overrule means O in okay. So the witness is okay to answer the question, and if there is some physical evidence being offered, it will be considered.
Yes, Your Honor. Miss Friendly, when was the last time he tried peeking into my window?
It was about 2 months ago.
When was the last time you noticed him driving by?
Last week.
Miss Friendly, has Mr. Filfo ever been violent towards me?
Yes.
Right now, we are getting to the heart of Ms. Gibla's case. Remember at the beginning that I told you that she had to convince me that the change that she seeks is in the best interest of her son Tommy? She is attempting to do that through her witness, Miss Friendly. This testimony is important to help me to understand her case. That means it is relevant to the case. In order for testimony to be considered by me, whether it's testimony, whether it is a document or some other form of evidence like a ring or a photo, that testimony has to be relevant to the case. It is relevant if it helps to disprove or prove something about your case. Let's return to the testimony of Mrs. Friendly.
How do you know Mr. Filfo was violent towards me?
Because I was there when it happened.
Here, before describing the incident, Ms. Friendly has shown that she has personal knowledge of the incident by saying she was there when it happened.
What happened?
Objection. Vegas the time.
Here's another common objection. Don't get frazzled. Just remember that whenever you or a witness talks about an incident, it needs to be mentioned when and where the incident happened. This is because it helps to establish that a particular incident is relevant. Usually, something that happened 2 weeks ago is going to be more relevant to your case than something that happened 10 years ago.
Ms. Friendly, can you say when what you described happened?
It was on a Saturday because that's when Mr. Filfo has his visits with Tommy at 2:30 2 weeks ago.
Okay. Ms. Gibla, you may continue.
Thank you, Your Honor. Miss Friendly, what happened 2 weeks ago?
I was babysitting Tommy while you went to the grocery store to pick up some things, and Mr. Filfo showed up at 11:45 and wanted to take Tommy for his visit.
Was that Mr. Filfo's usual time?
No, Mr. Filfo's usual time is at 2:30 in the afternoon.
Did you let Tommy go with Mr. Filfo?
No,
Why?
because the moment I opened the door, I saw that Mr. Filfo, he had glossy eyes, he smelled like liquor. He had obviously something spill all over his shirt, and I just didn't think I should let Tommy go with him in that condition.
What happened next?
He got mad, cussed at me, and just left.
Where was Tommy?
Tommy was, he was standing behind me the whole time. I told him to go into the other room so I could talk to his daddy, but he just wanted to be by me.
Sounds like this testimony could be helpful in determining what is in the best interest of the child, especially since Tommy witnessed what happened. Let's continue.
Did Mr. Filfo come back?
Yes.
What time?
He came back at 3:45 in the afternoon.
Was I already home?
Yes.
Were you still there?
Yes.
Why?
Because I was worried about you and Tommy. I didn't want to leave you alone.
Why were you so worried?
I heard some gossip from Rose, our neighbor, that when Mr. Filfo gets drunk, he gets into
Objection,
fights
hearsay.
and
As we said earlier, objections are used to keep out evidence, like the witness's testimony. Hearsay is another common objection. The reason hearsay is not allowed into testimony is because it's not reliable. Hearsay is a statement that's being made by a witness on the stand or testifying in court about another statement that they heard someone else say out of court. It would be far better to bring the person that had originally said the statement into court and let them testify to what they have personal knowledge about. That way the judge can rely on the testimony. Now remember, there are many exceptions to hearsay, so it could sound like hearsay, and yet the judge may still allow it into evidence.
Sustained. Ms. Friendly, you cannot testify about what you overheard somebody else say. Ms. Gibla, you may continue.
Thank you, Your Honor. Miss Friendly, what happened when Mr. Filfo came back?
he started pounding on the door, and then he came in and shoved you to the ground and started kicking your back and your side.
Have a seat.
Mr. Lawless, you will instruct Mr. Filfo not to engage in any verbal or non-verbal reactions to what a witness says. It shows great disrespect for my courtroom. Does your client understand?
Yes, Your Honor, he does.
Obviously, the way Mr. Filfo just acted, that's a big don't. Just remember, as soon as you step in front of the judge, anything you say and anything you do can be considered by that judge. That's why it's so important to be prepared and to always be respectful in the courtroom. If for some reason you do get a warning from the judge, immediately stop whatever you're doing, listen very closely, and allow the judge to finish speaking. Then, very respectfully, apologize. That's it. Don't make the same mistake twice.
Ms. Gibla, you may continue.
Thank you, Your Honor. Miss Friendly, what happened when Mr. Filfo started kicking me?
While he was kicking you, I was yelling at him to stop. And he went to go grab Tommy, and I ran to the door to stop him, and I immediately called 911. He then shoved me out of the way and let go of Tommy and just left.
So where was Tommy in all this?
Poor Tommy. He just, when he saw his dad kicking you, all he could do was scream, "Stop, Daddy, stop."
Again, this kind of testimony could be helpful for me in determining what's in the best interest of the child, especially since I have a third party, Ms. Friendly, who witnessed how Tommy reacted to his father's actions.
After that incident, did Mr. Filful do anything threatening towards you?
Well, Mr. Filfo does weird things. I remember him rummaging through neighbor's trash can a couple years back when he was still with you. And he also has this weird habit of talking to all the neighborhood dogs, especially my two little pugs.
Objection,
there's these-
non-responsive.
Non-responsive is another common objection. It means that the witness really isn't answering the question. Here, Ms. Gibla has asked whether her ex-boyfriend ever did anything threatening to Ms. Friendly. But instead of answering the question, Ms. Friendly begins talking about things really not related to the question. There's a lot of information that both parties wants the judge to hear about, but it's very important to keep your witness focused. Your question should be short and simple, and each question and answer should go to make a point in favor of your case.
Sustained. Ms. Friendly, would you please just respond to the question that has been asked? Ms. Gibler, would you repeat the question?
Yes, Your Honor. Miss Friendly, did Mr. Filful do anything threatening towards you?
Yes.
What did he do?
He, after that incident 2 weeks ago, he sent this nasty, threatening letter to me.
Your Honor, I'd like to show Miss Friendly the letter. It would be my first exhibit.
Would you hand it to the bailiff so that it can be marked?
Of course.
Up to now, we've been dealing with only one kind of evidence, testimonial evidence, or something that a witness says in court. But there are other kinds of evidence. There's documentary evidence, like a letter or a contract. There's also physical evidence, like a wedding ring. And finally, there's demonstrative evidence, things like photos, maps, and x-rays. These aren't the real object, they only represent that object. Right now, Ms. Gibla wants the judge to consider a letter, which is documentary evidence. The evidence she is offering will be labeled and referred to as an exhibit. In order to have the judge even consider her evidence, Ms. Gibla has to offer that evidence or exhibit to the court. That means that her evidence needs to be relevant and authenticated. We've already explained that something is relevant if it proves or disproves something about your case. To authenticate something, you usually need a person who has personal knowledge about that piece of evidence to confirm it and confirm its reliability, and basically prove that it's not a fake. After that, the judge may admit your evidence along with the other evidence already offered to help determine the outcome of your case. Let's see what Ms. Gibla does.
Have you given a copy of the letter to Mr. Filford, to his attorney?
No, Your Honor. I have 3 copies here. Can I hand it over to him?
Would you hand those to the bailiff? Let him do it.
Thank you.
You may proceed.
Thank you. Miss Friendly, can you take a look at that? Do you know what it is?
Yes.
What is it?
It's that letter that I was telling you about, Mr. Filfo.
Well, how do
sent
you
me.
know that?
Well, it's addressed to me and I received it.
Why do you think Mr. Filfo is the one who wrote it?
Because it mentions how I butt into his visit time with Tommy, and also I recognized his signature. He writes really small and slanted, Walt.
Are you familiar with his signature?
Yeah, I recognized it from the Christmas cards that I received from you for the last 6 years when you were together.
So, Miss Friendly, you said that the letter was threatening towards you. What was threatening about it?
Well, he says if I ever butt in again, he'll kick my ASS, and he also said he'll steal my dogs, my cute little pugs.
Your Honor, at this time, I'd like to introduce this letter into evidence.
You have just watched Ms. Gibla offer into evidence a letter from Mr. Filfo. This letter is relevant because it tends to show that Mr. Filfo has not only been threatening to Ms. Gibla, but to other people as well. Therefore, it could be in Tommy's best interest for Ms. Gibla to have sole custody over him. And it also might be in Tommy's best interest if Mr. Filfo has supervised visits. Ms. Gibla authenticated this letter by asking Mrs. Friendly what personal knowledge she had of the letter. Well, of course, she received it. And she also confirmed that she was very familiar with Mr. Filfo's handwriting. Let's see whether or not the judge will enter this into evidence.
Mr. Lawless, do you have any objections?
No, Your Honor.
It's admitted. Do you have any further questions?
Yes, thank you, Your Honor. Ms. Friendly, have you ever loaned me any money?
Yes.
When was this?
For the past 2 months, I've loaned you money to help with groceries.
How much money have you loaned me?
A total of $200, $100 each month.
Do you know why I needed to borrow money?
Because 2.5 months ago, you got laid off from your job, and you've been looking, and I know this because I've babysat Tommy while you went to job fairs and job interviews.
That's all my questions. Thank you, Ms. Friendly.
Mr. Lawless, cross-examination.
Yes, Your Honor.
Whenever you ask questions of another party's witness, you're doing what's called a cross-examination. Mr. Lawless is going to ask questions of Ms. Friendly. Ms. Friendly is not his witness, so basically, she's not going to really help out his client's case. So, Mr. Lawless is going to minimize anything that she has to say. Pay close attention to how he asks her his questions. He's going to try to keep her answers short, limiting them to yes or no answers whenever possible. Remember those notes that Mr. Lawless was taking earlier? Let's see how he uses those notes to ask Ms. Friendly these questions.
Ms. Friendly, you've known Mr. Filfo for about 6 years, correct?
Yes.
And in those 6 years, you never really gotten to know Mr. Filfo, have you?
No.
In fact, you don't even know where he works, do you?
No.
Ms. Friendly, you are actually Miss Gibla's former sister-in-law, correct?
Objection, Your Honor. I believe that's irrelevant.
This time, Ms. Gibla has objected. If you're going to object, you need to stand up and say objection, and then give a reason for your objection. And you must do this the moment you see or hear something objectionable. That's why it's so very important that you listen very closely to what is being said in court. Here, Ms. Gibla is objecting to Mr. Lawless's question because she feels it is irrelevant and has no bearing on the case. The judge will probably ask Mr. Lawless how his question will lead to relevant information. Let's see what the judge does.
Mr. Lawless, where are you going with this question?
Your Honor, I'm merely trying to establish bias against my client, Mr. Filfo.
Overruled. Ms. Friendly, you may answer the question.
Although Ms. Gibla gave a good try in making her objection, the judge overruled or disagreed with that objection. So the O in overrule should remind you of the O in okay. That means that it's okay for the witness to answer the question.
Can you repeat the question?
Yes, Ms. Friendly. Your brother is actually Miss Gibla's ex-husband, correct?
Yes.
So from the start of Miss Gibla and Mr. Filfo's relationship, you've never really approved of Mr. Filfo, have you?
Well, that's not exactly
Thank
true.
you. Nothing further.
Ms. Gibla, based on the questions Mr. Lawless asked, do you have any further questions of Ms. Friendly?
No, Your Honor.
All right. Thank you for your time, Ms. Friendly. You are free to go. Do you have any other witnesses, Ms. Gibla?
No, Your Honor. I don't have any more witnesses, but I would like to say a few things that would support my case.
Okay. Since you're unrepresented, I'm going to let you testify in narrative fashion. You don't have to do the question and answer that would normally be done. And I do remind you that you're still under oath. Do you want to take the witness stand, or do you want to remain there?
I'll sit right here, Your Honor.
Ms. Gibla is about to testify. In your case, you might not have any other witnesses, and it might be up to you to tell your side of the story. Be prepared and organized in what you want to say. Just remember that since you're testifying, you'll be treated like any other witness. You've already been sworn in, objections can be made against you, and the other party or the judge can ask you questions after you speak.
Okay, you may proceed.
Yes, Your Honor. As you heard from Ms. Friendly, Mr. Filful has been abusive towards me and Ms. Friendly and her dogs. What scares me the most is that, in fact, Mr. Filful has kicked me, pushed me, screamed at me, all in front of Tommy. And now Tommy has trouble sleeping. He is afraid of his dad. I don't know what to do. I want him to know his dad. And I don't want him around Tommy when he's drunk. When he's drunk is when he gets physical.
Obviously, this is another big don't. There are signs around the courtroom, and the bailiff often tells you to turn your cell phones off. So, turn your cell phones off. Let's see what the judge does.
This is a courtroom. Did you read the sign out in the hall about cell phones? Did you hear what the bailiff told you about cell phones? Is that thing completely off, or am I going to have the bailiff confiscated?
Yes, Your Honor, it's completely shut off. I'm sorry. I'm sorry.
Continue.
Thank you, Your Honor. Like I said, I'm not trying to keep Tommy away from his dad. It's just when I would feel better if there's an adult present when he's visiting Tommy. And I also want to say that child support, Ms. Friendly mentioned that she had lent me money. Well, I would like to say I recently got laid off. I was working for a Brady surplus store as a cashier. They had to let some of us go because of the economy. I was given a letter of termination. I would like to introduce it as evidence, if that's okay with you.
What is that letter going to establish?
Well, it'll prove that I don't have a job.
Mr. Lawless, does your client contend that Ms. Gibla is unemployed?
No, Your Honor, we'll stipulate that Ms. Gibla is unemployed.
Stipulate means to agree. So in an effort to save time and concentrate on issues that the parties are actually fighting about, both parties can agree on facts that are not in dispute. In this case, both parties agree that Ms. Gibla is unemployed.
Okay, very well. Then the court will accept that stipulation that he's unemployed, and you don't need to introduce the letter. You may continue.
Thank you, Your Honor. One last thing. Ever since I got laid off, I've been going to job fairs, job interviews. I would like to enroll myself in paralegal school. It'll be great for me and Tommy. It'll help us out. I can get financial aid and classes will start soon. I would like to mention that...
Ms. Gibla, just exactly where are you going with all of this? Would you
well,
speed this up, please?
Yes, Your Honor. Yes, I need money for childcare. I would like to put Tommy on a daycare center while I attend school. I've looked over the newspaper and there's 2 daycares nearby my home where Tommy can go. The cheapest one is $400 a month. Can I introduce this as Exhibit 2?
Just hand it to the bailiff, and if you've got copies,
Yes, Your Honor.
make them available so that Mr. Lawless and his client have them.
Yes, Your Honor.
Ms. Gibla offered the newspaper ads as her Exhibit 2. However, she doesn't need a person to authenticate the newspaper ads because newspapers are considered reliable by the court. All you have to do is show that the newspaper is somehow relevant or helps to prove something about your case. Here, in this case, Ms. Gibla offered the newspapers because they're relevant to help show that she needs more child support. Sometimes, certain kinds of evidence, when considered all together, help to prove one issue. These kinds of evidence are called circumstantial evidence. Here, in this case, Ms. Gibla offered 1. Ms. Friendly's testimony that Ms. Friendly loaned her money, 2. Evidence that Ms. Gibla lost her job, and 3. The newspaper ads about daycare to help prove that she needs more child support. These 3 things are circumstantial evidence, and they help to prove that one issue.
Okay, Ms. Gibla, anything else?
No, Your Honor.
Okay, for the record, I have received Ms. Gibla's income and expense statement, and is everything on that form true and correct at this time?
Yes, Your Honor.
Okay. Anything else?
No, Your Honor.
Mr. Lawless, cross-examination?
Yes, thank you, Your Honor. Ms. Gibla, were you surprised that you got fired from your job?
I was laid off, so yes, the economy's been really bad, and yes, I was surprised.
So you hadn't gotten into trouble at work in the past year?
No, not that I remember.
Ms. Gibla, isn't it true that you got reprimanded for stealing?
That was a misunderstanding, and I didn't get fired.
Isn't it true that Brady's Surplus Store does random drug testing?
Yes.
Isn't it also true that you tested dirty 2 years ago?
That was a while ago.
Isn't it true that you actually got convicted of the use of meth and possession of meth 3 years ago?
Yes, but I only got probation for that.
You know, at this time, I'd like the court to take judicial notice of Ms. Gibla's prior criminal conviction. You can reference case number BF123456Z.
Judicial notice is taken.
Another way to get evidence in is through judicial notice. Judicial notice will allow the judge to accept into evidence anything that is a readily accepted fact. A good example is June 12, 2009 is a Friday. Additionally, case information and judgments can be readily verified by the court. So, criminal cases can be judicially noticed. What this means is that past convictions can be brought up and considered by the judge.
Your Honor, I'd like to talk about that drug case. Since then, I've taken drug classes, and I've been sober for the past 2 years.
You got high last
Can
night.
I finish
You had my
speaking?
son out
You're
there
just
last
jealous.
Enough!
Hold on.
Enough!
You're a real man.
Sit down!
night.
I don't want to hear either of you two talking to each other anymore. In this courtroom, you will speak only when it is your turn. No more warnings. Do you understand?
Yes, Your Honor. Sorry.
Yes, Your Honor.
Obviously, this is no kind of behavior for the courtroom. Always talk in a respectful manner and never speak to the other party directly, even if that other party is yelling at you. Let that party look crazy and unreasonable. This is emotional stuff. However, you need to control your anger, your hurt, and frustration. If you get into a shouting match with your ex, that only distracts from your case. Remember, the judge can consider anything you say and anything you do. You do not want the judge to think that you are the hot-tempered, crazy person. Stay focused, remain calm, and always be respectful. We hope that this video was helpful to you and that you feel better prepared to present your case in court. If you have any questions, you can always contact Greater Bakersfield Legal Assistance or the Family Law Facilitator's Office. Remember, we're here to assist you in helping yourself. Here's a quick review of what you need to know for your hearing. What's the burden of proof for your case? What evidence is and how it's used? And what objections are and how they are used? Burden of proof. In court, you have the burden of proof or the responsibility to prove up your case. It's not enough to just give some random evidence here and there. A preponderance of the evidence, or about 51% of the evidence, has to support your case. Since you're asking for something that would affect your child, you need to show that it's in the best interest of the child. And since you're asking the judge to change an existing order, you need to show that there's been a change of circumstance. Evidence. You need to prove your case with evidence. All evidence needs to be relevant, and sometimes you need to authenticate it. There are several kinds of evidence. Testimony evidence and documentary evidence are the most common. When physical evidence is offered, it is referred to as an exhibit. Testimony evidence is when someone, under oath, talks about something relevant to a case. That person is called a witness. Usually, a witness needs to have personal knowledge about what he or she is talking about. Physical evidence is any kind of physical object, like a ring or a photograph. It also includes documentary evidence, like a letter or contract. All physical evidence needs to be relevant to your case. You also usually need someone to authenticate that evidence or exhibit. That means that a witness who is familiar with that evidence must explain what it is and how he or she knows about it. Objections. Objections can prevent evidence from being considered by the judge. Common objections are calls for speculation, hearsay, non-responsive, and irrelevant. After an objection is made, the judge has to make a ruling. The judge will either sustain or overrule. If the judge agrees with the objection, the judge will sustain and the evidence is stopped. So the witness cannot answer the question, or if it's physical evidence, it will not be considered. Now, if the judge does not agree with the objection, the judge will overrule and the evidence is okay to be considered. That means that the witness can answer the question, or if it's physical evidence, it will be considered. Final tips. Here are some helpful do's and don'ts for you to remember. Definite do's. Know where you are going. Are you in the right building? The right floor? The right department? If you're not sure, you can check the court calendar that's usually posted right outside the courtroom. It will have a list of cases scheduled for that day. Do dress appropriately. Be early. Bring all of your documents. Make sure your witnesses will be on time. Bring a pen and paper to take notes. Bring a small calendar. Your case might be continued or postponed to another day, so you will want to know if you're available for the next proposed hearing date. Also, during your hearing, if past dates are mentioned, you might want to confirm that correct dates are given by using your calendar. Do speak clearly. Show respect. Listen to the judge, the other party, and all witnesses. Don't do any of the following. Don't argue with the judge, the other party, or any witness. Don't guess or ask your witnesses to guess. Don't stare, mad dog, roll your eyes, or sigh loudly in response to the judge, the other party, or any witness. Don't leave your cell phone on. Turn it off completely. Don't chew gum, eat, or drink anything while in the courtroom. Don't forget about parking. Did you park in 2-hour parking or at a parking meter? If so, you can get a ticket if you don't move your car or put more coins in the meter.